Now that we have spent more and more time thinking about the nature of the Anglo-Saxon legal system, and looking at some of the more conceptual ideas surrounding the Anglo-Saxon legal system, this video specifically is going to look at the structure of the Anglo-Saxon legal system. What did the legal system actually look like? How did it develop? And under some of the more important and prominent monarchs during the Anglo-Saxon period, how did it develop over time? So we're looking more at the institutional structure of the Anglo-Saxon legal system rather than necessarily thinking about the substantive law. So we're not talking necessarily about the legal concepts, we're talking about the systems that existed, the structural systems, the institutions, the courts, the groups, the law codes that essentially established all of these kinds of substantive legal principles. And I want to begin by thinking about the nature of the court system. So the thing that we have to remember is that, of course, this is not a unifying system of law that took place during the entire period of the Anglo-Saxon history. Of course, the Anglo-Saxon history took place over a good 500 or so years, and you have to remember that these court systems and the law code systems and all the other kinds of councils that we will see developed over time. So they didn't all begin like this, it all developed over time, of course. But generally speaking, throughout the Anglo-Saxon period, local justice would be administered through a number of different courts. These become known as folk moots or moot courts. These were assemblies of local freemen who would come together and they would settle disputes, they would do land allocations, and they would enforce the customary local laws that had been passed down and practiced within local communities for centuries. These moots were often held at a variety of levels, and they included the more substantive courts known as the Hundred Court and the Shire Court. The hundred itself was a geographic division within a particular shire or a county, and the court of the hundred court, dealt with local disputes, particularly relating to minor criminal cases or issues related to the allocation of land, the issues of inheritance, etc., etc., etc. They were presided over by somebody known as a reeve. A reeve was an official that was appointed by either the king or the local lord. Remember, this is not just the king of England, this is the king of whatever kingdom that we're thinking about within the heptarchy, either Wessex or Northumbria, for example, or any other of the parts of the heptarchy itself, or Mercia, for example. So bear that in mind, obviously, when thinking about this period of time. And so, essentially, the Hundred Court was named after the geographical division that it presided over. So, the Hundred was the geographical division that was within a shire or a county, and the Court of the Hundred was the court of that particular geographical division. A shire court, on the other hand, was a slightly higher level court than that of the Court of 100. A shire court would operate at a higher level and dealt with more serious cases. It was presided over by somebody known as a shire reeve. Sometimes, eventually, that would become as you can sort of hear when you think about the sort of linguistic development, that begins to shift into a sheriff, shire reeve, sheriff. You can sort of see how that word develops into the word sheriff. And so a shire reeve is an individual who would preside over the more serious cases at the shire court level. And again, like I said, eventually turns into a sheriff as the title. And also by somebody known as an ealdorman, which becomes who is a king who is appointed as an official for the shire. So you have an ealdorman and you have a shire reeve, and these are the individuals that sort of are appointed to this higher level court that deals with more serious cases. They were important for the enforcing of royal decrees, and they were important for the resolutions of disputes that didn't just affect individuals or very localized local communities, but instead would affect the much broader community itself, the community of the shire or the county, rather than the community with communities divided within that shire or county. At an even higher level, when we start to think about the king themselves, you have the witan, something known as the witan, otherwise translated into the Council of the Wise. The witan was an assembly of noblemen and church leaders, and these were quite high up noblemen and church leaders, people who sort of sat in the upper echelons of the kingdom, and they would advise the king on matters of laws and governance. So we're talking less about the sort of local administration of justice here with the sort of Court of the Hundred and the Shire Court. We're talking now about the central administration of the kingdom. We're thinking about the Council of the Wise, the witan, the establishment of a council that would advise the king, that would advise the individual who is in control of the kingdom. Although the witan was primarily seen as a political body, of course the distinction between law and politics is not exactly clear-cut during the Anglo-Saxon periods, it was still nevertheless seen as primarily a political body. It would also be important in terms of playing a role in the development of law, particularly when we start to see in the middle to later period of the Anglo-Saxon period the establishment of the law codes, the royal law codes of the kings of that particular time. We'll talk about those in a second. So the calling of the witan would be in the development of new legal treatise that would be created in the sense of law codes, but would also primarily operate as a political institution, a political body. The king would often seek the approval of the witan when it comes to the issuance of new laws and when it comes to the administration of justice in the kingdom at the centralized level. Again, we're thinking not just about England, we're talking about the centralization of justice in the kingdoms of the Heptarchy. We're talking about the centralization of justice in Mercia, the Mercian witan, for example, or the Wessex witan, or the Northumbrian witan. Bear that in mind. Of course, this would develop into a more unified system as time goes on, but for now, that is what we are thinking about. And the witan, as I just mentioned, was important for the establishment of the royal law codes. As the Anglo-Saxon kingdoms became further and further consolidated over time, the kings would begin to issue law codes that would standardize the legal practices across their various different realms as they would take further and further parts of territory. These law codes were intended to not overrule the basic customary laws that existed at the local level, but they were intended to supplement those local customary laws, and they were intended to address issues of a variety of different natures. So, as I mentioned in an earlier video, things like criminal justice, property rights, and public order. The earliest of the law codes, as we already know, is that of King Aethelberht of Kent from around circa 602 AD. This is one of the earliest examples of a written law within Anglo-Saxon England. It focuses mainly on the establishment of the detailed weregild system that we looked at in the previous lesson. We noted that for injuries and homicides, the weregild system was established to essentially compensate whatever injury and whatever grievance had taken place. And we used examples of a loss of a finger, the breaking of a tooth, the breaking of a bone, the killing of an individual, and the established weregild that would be necessary to essentially compensate that particular injustice. One of the most important figures within Anglo-Saxon England is undoubtedly Alfred the Great, who was in control and lived from around 871 to 899 AD, and Alfred's law code is one of the most important as a result of that. He combined the earlier laws from different regions with a number of biblical principles in Christian ethics. So Alfred the Great was a devout Christian, at least when he came to the throne eventually. He was never seen as, at least historians don't necessarily see him as, somebody who was always born to be a ruler and born to be a king. He was sort of probably not cut out for that kind of work, but nevertheless he found himself in the position of the King of Wessex. And so when we think about that, he was particularly devout. He was a particularly intellectual individual from what we know. He was somebody who sort of strived to see greater amounts of intellectual and philosophical learning and theological learning during his reign and within sort of his sort of local area. And this was imbued in his establishment of his law code. His law code sought to unify the kingdom. It sought to establish a consistent legal framework based on justice and fairness. And so his law code is a very important source of not only a good understanding of this period of history and this period of legal history, but also seeing the shift and the sort of imbuing of Christian principles more and more and more into the legal system that we know of to this day. Finally then, another example of a law code is that of King Cnut from 1020 to 1023. King Cnut ruled a vast North Sea empire, and this North Sea empire included England, and he would issue a comprehensive law code that would actually see a mixing of and an intermingling of not only the Anglo-Saxons, but also Danelaw and the Danish. And don't forget, of course, that sort of from around the 7th century onwards, you see the influence and the growth and establishment of the Vikings. The Vikings land in England. They first settled down in Lindisfarne. That's where they first established some kind of territory within this period of history. And the Danelaw, the establishment of Danelaw, which is the sort of not only the system that is described as the sort of legal administration of the Danish kingdom, but also the sort of territorial area of the British Isles that the Danes actually control. It becomes known as the Danelaw. And King Cnut, later on in the Anglo-Saxon period, is somebody who is very much influential in the way that he developed an establishment of Anglo-Saxon and Danish legal traditions mixed together. Cnut's laws sought to maintain order and to promote stability in what effectively is a multi-ethnic kingdom. What is effectively a kingdom that shares a distinction in terms specifically and most importantly of religious tradition. You sort of have the pagan king, the pagan beliefs and the pagan mythologies of the Danish, with the sort of Norse mythology that they believed in. And then, of course, you have what is considered, quote-unquote, the enlightened beliefs of Christianity. And this was a source of conflict among a variety of different Anglo-Saxon kings and Danish rulers that we see taking place throughout the sort of Viking invasions of England.